Well, hello. Good afternoon if you're on the East Coast, and good morning if you're way out west. I think we do have some friends from the islands of Hawaii maybe tuning in today. By the way, for those folks, just a reminder, Thompson-Coburn does do on-site training and reviews, and we are amenable to bartering for luau's and surfing lessons. So let us know, friends in Hawaii, if we could come out and see you. You're listening to the department's new Title IX rule, a careful review and suggestions for public comment. This is part of Thompson-Coburn's higher education webinar series, and we're going to be talking today, as the title suggests, about the new proposal for revisions to the Title IX rule that we recently saw out of the U.S. Department of Education. While folks are still joining, I'll go ahead and jump into housekeeping, as we always do. First of all, just keep in mind that if you have questions during the webinar, you can submit them through the Q&A widget at the bottom of your screen. And we're going to try to answer these at the end of the webcast. We are scheduled for 2 hours today, and we expect to use almost all of that for content because there's a lot of ground to cover. But we also have 15 minutes after that 2 hours is up before we get kicked off the platform, and we will try to make sure that we can get through at least 15 minutes of questions. And if we finish a little before the 2 hour mark, we'll certainly start before then. A copy of today's slide deck is available in the resource widget. We encourage you to download any and all resources or links that you may find useful. We're going to point you to some other resources today. As always, our slides include live links so that there are, it should be easy to access a number of other resources if you like. And if you have trouble getting the slide deck or anything else, you're always welcome to just reach out and give us a holler. You can find additional answers to some common technical questions located in the Help widget at the bottom of the screen. As far as CLE goes, if you're a lawyer type and you're tuning in for continuing legal education, today's webinars are credited in California, Illinois, and Texas for 2 hours of general CLE, and in Missouri for 2.4. Also general CLE in that case. The webinar is also CLE accredited in New York for 2 hours of experience and transition credit. Keep in mind we award CLE based on attendance for the entire 120 minutes. So during this presentation, you won't see the old automated pop-ups, but instead you'll see secret words. We did secret words 3 or 4 years ago, then we went to pop-ups, now we're back to secret words because the laws keep changing in various states. So please do keep an eye out for those secret words so that when they pop up, you can just hit the radio button and make sure that you get your credit for CLE. Finally, after the presentation has concluded, there will be a survey, and we're always extremely grateful to folks who can stick around and fill out the survey because we absolutely review all of those comments. One of the comments that we do frequently get is, boy, you covered a lot of ground. It would be great if you could talk more slowly. I will tell you today we will do everything in our power to move forward at a deliberate pace. That having been said, as you'll see in a minute when we get to the syllabus, there is a lot of content to cover, which I mentioned earlier. My suggestion, strong suggestion to folks is, I know it's for many the afternoon, grab a cup of coffee or other beverage of your choice, depending on just how challenging you find the material, but sort of sit back and relax and let it wash over you. Look, the webinar is going to be recorded. It's free and on demand after the fact, so you can always go back and review it. You've got the slides. Please don't feel like you have to absorb and digest and remember everything that we're saying because, again, we're trying to cover a lot of ground. This rule in its unofficial version was 700 pages. I'm sure even when it hits the Federal Register, it will be lengthy. There's just a lot to talk about, and I don't want you all to feel like frustrated because so much is coming at you all at once. So again, if we pass over something and it doesn't quite register, just remember you can always come back to it. You can listen to the webinar, you can reference the materials, or you can even give us a call. But I don't want you to feel like you've got to absorb everything in real time. For those of you who don't know us, Thompson-Coburn is a law firm, so the people you're going to hear from today are lawyers, and we are all part of the higher education practice at this firm, which means we have a group of attorneys who work full-time or a lot of the time with institutions of higher education on a wide range of matters, but certainly including discrimination law and areas like Title IX. The person you're hearing right now, I'm Aaron Lacey. I'm the partner and chair of the higher education practice and do lots of different things for schools. Here we included, just for today's webinar, we don't always do this, but we included our little academic credentials down there. So I'm a Duke and Vandy guy. You will also be hearing from Scott Goldschmidt, who is a counselor in our higher education practice, who sits in our DC office. I'm physically in St. Louis, so looking out at the arch right now. Scott was previously the Deputy General Counsel for Catholic University in the DC area and was there for many years through the evolution of Title IX, going back really sort of to the Obama administration when things started to really change. And he's a Catholic University and GW guy, so DC all the way. And then finally, we have our colleague, Stephanie Cohen, who is really a labor and employment law litigator, but has done a ton with our higher education practice, particularly in the area of discrimination law, student affairs, and policy development. And Stephanie is a GW grad, Harvard and Emory, although Harvard, some of you may not recognize, more commonly known as the Duke of the North. So that may help you remember where she went. I've told her for weeks I've been planning that joke. All right, so here's the syllabus for today. A lot of ground to cover. We're going to start out just very quickly talking about Title IX in general, but this is definitely an advanced topics webinar. We're not going to spend a lot of time. We just want to level set. And then we're going to kind of jump into it. And we're going to talk first about the obligation to respond and how the proposed rule sort of expands and casts a much broader net. We're talking about some important proposed definitional changes. And then we're going to talk more and sort of get into procedures, and we have a graphic for you, procedural waterfall, that we've put together we hope is helpful. And then we're going to talk, notification, Title IX coordinator responsibilities when you get a notification of sex discrimination, informal resolutions. We're going to get into the grievance procedures that have been proposed and the revisions sort of that framework. And finally, we're talking about new training requirements, retaliation, and a real focus of this proposed rule, apart from all of that other stuff, there's sort of an interesting focus on discrimination based on pregnancy or marital status, and so we're going to talk about that at the end as well. Okay, so let's jump on in. First of all, just a level set, we are talking about the Title IX statute, so it's Title IX of the Education Amendments of 1972, which is very short if you look up that statutory language, and prohibits discrimination on the basis of sex in any education program or activity receiving federal financial assistance. Some important concepts here. First of all, it covers all forms of discrimination based on sex, not just equity in athletics, which is what most of us thought for many, many years, or sexual misconduct on campus, which is what we tend to think of now. Just keep in mind when we talk about sex discrimination, it's athletics, it's sexual misconduct, but it's also discrimination in employment or hiring or recruiting or financial aid or any of your programs or activities, which basically means any of your operations on campus. It does protect both students and employees. I think often folks are a little surprised by that who don't have a lot of familiarity with administering this regulatory framework. It applies to all institutions that receive federal financial assistance, which I'm going to guess is everybody on the line, and it's enforced by the Office of Civil Rights within the U.S. Department of Education. I mentioned earlier, it's not just equity in athletics and or sexual misconduct. There's not much to the statute, but the regulations that came along back in '75, just very shortly after the statute, amplified considerably that statutory language. And the regulations touch on lots of different areas with regard to students, admissions, recruitment, programs, housing, facilities, counseling, athletics, again, just about every aspect of your operations. And then similarly with regard to employees, it's not just employment, but it's recruitment, comp and benefits, job classification and structure, advertising, gets at pre-employment inquiries just like it gets at pre-admission inquiries with regard to students. So this idea of sex discrimination in Title IX, we're talking about all forms of sex discrimination in almost all aspects of your operations. And again, we're talking about covering both students and employees. So in 2020, the U.S. Department of Education promulgated the first significant regulation addressing sexual misconduct on campus since 1975. So those of you in the know, and by the way, at the end of this presentation, we have a Title IX timeline that we have sort of kept up and current over the last 3 or 4 years that goes all the way back to when the statute first was released all the way up to just the release of this unofficial rule, and it's got links to all underlying resources and the dates all in sort of a calendared format. It's a really useful resource, and it's a nice way to sort of bring together and have all links to all these resources in one place. But the critical point is, from 75 until 2020, there was no significant new set of regulations added that really concerned sexual misconduct on campus. Again, those of you in the know are aware that most of what we saw during the Obama administration, while significant and meaningful to schools, was in the form of sub-regulatory guidance. So it wasn't new regulations, it was new pamphlets and Dear Colleague letters and things along those lines. So it was in 2020 that we got the new rule out of the Trump administration. And it really put into place, for the first time, a complicated framework for managing allegations of sexual harassment or sexual misconduct on campus. In April 6, 2021, so just very shortly after the Biden administration moved in, one of the first items on their agenda was to announce that they would be overhauling the 2020 Title IX rule. On June 23rd, so just a couple of weeks ago, the department released the unofficial version of its proposed revisions to the existing regulation and invited public comment. Now, there's a couple of important points I want to make. The first is we're going to be talking throughout the day about this proposed rule. So everything we're discussing is proposed. It's not actual law. I have found that attorney types like the presenters here sometimes take for granted these nuances, and I will have conversations occasionally with clients who there will be some confusion on this, and they'll think, well, this is the new rule, or the new rule has just come out. That is not the case. What we're dealing with right now is proposed revisions to the existing law, but none of what we're talking about today is actually a new rule yet. In fact, these proposals have come out, and what the department is doing is it's asking for you all to comment. The other thing that I want to highlight is all we've got right now, as of today, I checked the Federal Register this morning, I believe that it is still the case that the official version of this proposed rule, which will be a notice of proposed rulemaking that will show up in the Federal Register, has not actually hit the Federal Register yet. So what we've been looking at is the unofficial version that came out June 23rd. Now, we would expect very little to no change between the unofficial version and what shows up in the Federal Register, other than some cleanup and maybe some filling in a few blanks. But why that's critical is because the timeline for comments runs from the day that the notice of proposed rulemaking, this new proposed rule, actually hits the Federal Register, and that timeline hasn't actually started yet, and that's good. So you can go ahead and start looking at the unofficial version that's out. If you're participating in this webinar, you're getting ahead of the curve, because we're going to talk to you about it today and try to give you a real sense as to what's in it, but your 60 days to comment hasn't actually started ticking yet. When it does start to tick, you're going to be able to make comments via the federal e-rulemaking portal. In fact, the department these days is really reluctant to accept comments in hard copy. I think it is still possible in limited circumstances to submit them that way. But the real expectation is that you'll go in through this federal e-rulemaking portal and do it in that way. By the way, when you see these pictures on the right on the screen, you can click on that picture in addition to the link, and it'll take you to the e-rulemaking portal. The referenced docket ID for this NPRM, Notice of Proposed Rulemaking, is here in front of you. I have it in brackets because this is the ID number, the docket ID number that shows up in the unofficial publication that came out on June 23rd. Just double check the Federal Register when it comes out officially in the Federal Register and make sure that that reference docket ID number is still the same. Candidly, if you go to the Federal e-rulemaking portal, you can see in this little picture there's sort of a search thing. If you put in Title IX, it'll probably pop up, but I just don't want anyone to be misled. That should be the docket ID number, but it was in brackets in the unofficial rule. It's possible that that's one of the things they update when when the official version of this proposal comes out in the Federal Register. So please just keep that in mind. Okay. As you're thinking about whether or not you want to comment, just a couple of other things to think about. First of all, the department did put out a summary of major changes chart. I don't know how helpful it really is. Candidly, I think this presentation will be much more helpful, just in the sense that this is a lot more detailed. The summary is only a couple of pages long, so there's only so much that it gives you, but we wanted to give you a link to it. We also created a comparison document as you may know, when the department puts out proposed rules in the Federal Register, it doesn't run a red line. What it says is this is all the new stuff, and it sort of in writing tells you how it's going to change the existing law, but it doesn't actually create a comparison document to show you the changes. We did that. I know some folks don't like these. They find them confusing. Other folks, a lot of attorney types, find them extremely helpful. So if you want to see the comparison we put together, you can just click on the link and pull that up as well. If you have time, try to get through the preamble to the proposed rule. There's always a lot of good information there where the department talks about why they're doing what they're doing at great length. And then finally, of course, you've got the slides in this presentation that will be recorded. But to the extent you're thinking about comments and you're trying to really get your brain wrapped around all of this, hopefully the things on the page here and the materials we're producing will help you do that in an efficient way. Okay. With that being said, let's really get into the substance of the rule. And with that, I'm going to turn it over to my colleague, Mr. Goldschmidt. Scott, take it away, sir.
Thanks, Aaron. Pleasure to be with everyone. And yeah, we get to start with the fun of diving into this 700-page preamble and proposed rule. Thinking about how to most efficiently do this, I wanted to start with a framework that might be helpful. Again, assuming that most people on this call are fairly familiar with the current rule, the current structure, the current framework, a lot of this is going to look familiar. The department's fact sheet they put out that Aaron just referenced, they state that the regulations that the department aimed to keep as much as the current regulations as possible to ensure consistencies with schools. So as we go through this, as we go through the nuts and bolts, a lot of this is going to look familiar. The reason for the 700 pages, as you'll see, is the details have changed. So in the real estate analogy of this Title IX rule, the department has decided the bones of the house are good. The framework is still there. You're going to see a lot of things that are familiar to you, but really just gutted the inside, the definitions and the scope and everything we're going to talk about later. And oh, by the way, they added a second level to the house as well and really broadened the scope of this Title IX rule. So with that, again, just on the broad 30,000-foot view, always good to have that in mind as we're going through the nitty-gritty before we get there. Just remember your obligations to respond under the rule. So under the proposed rule, schools have to take prompt and effective action to end sex discrimination that occurred in its program or activities, prevent its reoccurrence, or remedy its effects. And again, this should be familiar. This hopefully is not new. The proposed rule also requires the Title IX coordinator to take certain steps upon being notified of conduct that may constitute sex discrimination under Title IX by an employer or any party without regard to whether a complaint's been made. So with these kind of broad obligations in mind, we wanted to kind of get into the first part of the nitty-gritty, which is changes to our definitions. And as speaking with lawyers, you know, once the definitions are a heart of the rule, a big part of what your obligations are. We're throwing this heat map up just to kind of show you what was changed and what's new. And as you'll see, there's a lot there. We're not going to spend too much time on a lot of these, but we're really going to kind of dive into the most meaningful definitions. This hopefully just gives you a sense of what the scope of the definitions that the department has decided to remove, to change, or to add. And that first definition we'll talk about is sex discrimination. So as Aaron mentioned, Title IX is a very short statute. It's 37 words, but really the important distinction is discrimination on the basis of sex is prohibited under Title IX, and that's what obligates the school's response. Now, on the basis of sex has been subject to different interpretations across different administrations. The Obama administration had their guidance. The Trump administration, 2020, 2021, indicated that Title IX scope, that the definition of sex should be rooted in biological sex. And then in 2020, we have the Supreme Court decision, Bostock v. Clayton County. And that decision concluded discrimination on the basis of sexual orientation and discrimination based on gender identity inherently involved treating individuals differently because of their sex. It reached this conclusion in the context of Title VII of the Civil Rights Act of 1964, which is an employment statute. But as you may be aware, courts rely heavily on interpretations of Title VII to inform their interpretations of Title IX. So Bostock is very important in the Title IX context, because in June of 2021, the Biden administration put out a notice of interpretation. They've published this in the Federal Register to make clear that the department interprets Title IX's prohibition on sex discrimination to encompass discrimination based on sexual orientation and gender identity. This is not new for the new rule. This is hopefully review. This is hopefully not old news, but it kind of sets the stage of this broader definition of sex discrimination and why the Biden administration decided to make the changes that we're going to show you in a second. And so here's this new definition. So building on that OSTOC decision, building on that notice of interpretation, the proposed 106.10 states that discrimination on the basis of sex includes discrimination based on sex stereotypes, sex characteristics, pregnancy or related condition, sexual orientation, and gender identity. Again, this was previewed heavily in the news. Hopefully this proposed change is not much of a surprise, but certainly one of the key aspects of the Biden administration's rule is to expand kind of who is covered or what's covered under Title IX, what is discrimination on the basis of sex. And as Aaron mentioned, we're gonna, as we go through these changes, think to yourself, is this something that you might wanna comment on? And important to mention, comments can be both positive or negative. So depending on how your institution feels, if you think the department did a good job in kind of determining this new definition of sex discrimination, a positive comment telling the department they got it right is important as well, along with a potential negative comment, as we'll see, maybe certain rules or certain definitions kind of lead to a result that is less than ideal or unwieldy. So moving on, so we have our expanded definition of sex discrimination. Now we're going to get to sex-based harassment. So if you remember, one of the linchpins of the 2020 Trump administration rule was sexual harassment. So that is out, that is replaced by this new concept of sex-based harassment. So sexual harassment's out, sex-based harassment is in. As you'll see, it's broader than sexual harassment. So sex-based harassment includes sexual harassment. It also includes some of those aspects we spoke about under sex discrimination, sex stereotypes, sex characteristics, pregnancy, sexual orientation, and other sex-based conduct. So the potential bases are broader under this sex-based harassment, which is our new kind of triggering definition here. But the conduct should be familiar, right? So quid pro quo harassment, certainly the similar concept or the same concept that we've seen in the current rule. Hostile environment harassment, which we'll explain is kind of a derivation of one of the bases in the current rule, and the Cleary and VAWA crimes, so sexual assault, dating violence, domestic violence, stalking, kind of all familiar. So again, this should ring familiar, that this should not be new, but we're going to kind of go into some of these definitions more and kind of see what the department did, even though they're keeping the same concepts, with how they made them broader. So the first is quid pro quo harassment. Again, that's the this for that. It's conditioning part of the institution's education and program or service on unwelcome sexual conduct. The current regulations, the ones in effect now, are only limited to an employee. So an employee was the only person that could action quid pro quo harassment. Again, the department made it broader here, and hopefully you're seeing a theme. It included agents or other authorized people, authorized person that could be a perpetrator of quid pro quo harassment. In the NPRM, the department explains an agent or other authorized person could include unpaid or volunteer coaches, graduate students who may not be employees, internship clinic supervisors, volunteers, board of trustee members. So all of those individuals could, if they performed quid pro quo harassment, be subject to or be prohibited under this definition. The department also says in the preamble that likely would not include students in positions of responsibilities for a team or a club. The other difference between the current definition and this definition is the current definition only references explicitly conditions the provision of aid on services. Here, the department comes out and says explicitly or implicitly conditions certain unwelcome sexual conduct. So the department made clear that we're broadening it again to include an agent or other person, and implicitly conditioning aid as part of this potential harassment. So a fairly significant change here, and we'll spend a little bit of time on hostile environment harassment. So under the proposed rule, hostile environment harassment is unwelcome sex-based conduct, sufficiently severe or pervasive, based on a totality of circumstances and evaluated subjectively and objectively, that it denies or limits a person's ability to participate in or benefit from the school's education program or activity. Okay, so let's unpack this. For those of you who have dealt with employment law or litigation and are familiar with Title VII, the standard's a lot closer to the Title VII standard than the previous Title IX standard. Again, going back to the current rules, remember the current definition that's similar to this hostile environment harassment is unwelcome conduct that's so severe, pervasive, and objectively offensive that it effectively denies equal access to the education program or activity. Typically, it's difficult, or in certain situations, it was difficult to have all three, led to a number of dismissals under Title IX, and was one of the reasons that schools had two-track policies to address conduct that might be severe, but not severe, pervasive, and objectively offensive. Here, one of the changes the department made, and again, probably no surprise, is that it's not this severe, pervasive, and objectively offensive standard. The conduct to be hostile environment harassment only needs to be severe or pervasive. So it certainly makes it a little easier standard to meet. The totality of the circumstances is new. That just means based on all the publicly available, based on all available information. The old standard had only an objective view of this potential harassment. Here, the department adds a subjective and objective element to the potential harassment. Again, objective being how a reasonable person would view it. Would a reasonable person consider this to be hostile environment harassment? Subjective, how the complainant actually views it. And denying, or it's not just denying a person's ability to participate in a benefit, it's denying or limiting a person's ability to participate. So a lot of changes here, certainly potentially broader aspects of what could be considered hostile environment harassment, and I think the department certainly did that on purpose to try and capture more conduct kind of in the realm of Title IX. The definition also makes clear that whether a hostile environment has been created is a fact-specific inquiry that includes considerations of 5 topics. So the first, the degree to which the conduct affected the complainant's access to the education program or activity. This is a non-exclusive list, but the department provides a fairly good summary in the NPRM about kind of what is potential for each of these elements. So with regard to the first, the department says that it could be grades going down, withdrawal, mental injuries, emotional distress. The department also says students may be able to maintain grades or participate in sports but find it difficult to do so. Again, they're not denied equal access, they just kind of find it more difficult. That could be hostile environment harassment. It can exist even if the complainant is not the target of harassment. So in a classroom, if the harassment is targeted at one student, another student that experiences it could be a victim of hostile environment harassment under this proposed concept. And again, moving to the second one, the type, frequency, and duration of the contact. The department explains the more severe and pervasive the conduct is, the more likely it is to create a hostile environment. And the more severe the conduct, the less need to show repetitive series of incidents. Again, this is probably not new from the current regulations, but the department makes it clear. The parties' ages, roles, previous interactions, and other relevant factors. Here, the department says that due to the level of control of a professor, teacher, or coach over students, harassing conduct by that person is more likely to create a hostile environment than similar conduct by students. The location of the conduct and the context in which it occurred. The department says that harassing conduct that occurs in a personal or secluded area, such as a dorm room or a residence hall, can have a greater effect, maybe is more threatening than similar conduct in a public area. On the other hand, the department says that harassing conduct in a public space could be humiliating and kind of lead to a hostile environment under that context. And last, other sex-based harassment, the kind of the catch-all. And here the department gives the example of students' peers repeatedly denigrating a student as girly over a period of weeks, causing him distress, interfering with his ability to concentrate. The recipient has an obligation to determine if hostile environment exists, kind of based on that catch-all category. Proposed definition-specific offenses. So these are not, do not change much from the current regulations to the proposed. So I'm going to kind of go over this fairly quickly. Again, the department is using the rape, fondling, incest, statutory rape, dating violence, domestic violence, stalking. One of the big differences is instead of linking to cross-referencing aspects of the code, the department either puts the full definition, as in the case with dating violence, domestic violence, or stalking, or here, or with the potential rape, fondling, incest, or statutory rape, just says that how it is under a forcible or non-forcible sex offense under the Uniform Crime System of the FBI. Two important details here. So the first, with the rape, fondling, incest, statutory rape definitions, there was confusion about which FBI Uniform Crime Reporting Standard was the appropriate one. The department here clarifies that under the Clery Act regulations, if you look to Subpart D, Appendix A has definitions that could potentially be used, or they suggest that would meet the standard, again, for schools that have the carnal knowledge definition of rape and those kind of definitions. That could be a difference there, so please be sure to take a look at that. And the dating, domestic violence, and stalking definitions are from the reauthorization of VAWA that's going into effect in 2022. Again, the department puts those definitions into the statute, so there's no issues there. Just be aware that the VAWA definitions of those crimes are changing as of October 1, 2022. So just a general practice point, your institution might need to update your Title IX, Clery, or other policies or procedures that link to VAWA definitions depending on the changes in the laws. A note on unwelcome conduct. Again, unwelcome conduct is key to quid pro quo and hostile environment harassment. In the interest of time, I'll leave this slide for kind of self-study for review, but I think I included it because I thought it was a pretty helpful explanation on what kind of unwelcome conduct was. The department has chosen to provide helpful explanations somewhere and leaves other aspects to be desired. So just pointing out this was a fairly good discussion on unwelcome conduct. But I want to spend a little bit of time on the scope of program or activity. So a little confusing, program or activity, same as the current regulations, referenced twice, first in 106.2 and again at 106.11 in the proposed regulations. Here we're focused on the 106.11 regulations. Currently, program or activity, as we know, includes location, events, circumstances over which the recipient exercised substantial control over the respondent and in the context in which the harassment occurred. So that includes buildings owned or controlled by student organizations, and the geographic scope was limited to inside the United States. Again, so the department currently, the current regulations have limited kind of the scope of program activity for the purposes of these Title IX grievance procedures. And again, another reason many schools had two-track policies. If they want to address sex discrimination outside the scope of that program or activity, they would need to address it in a non-Title IX sex discrimination policy. So a few similarities in the proposed rule and a few differences. So the first similarity, program or activity includes all your academics, extracurriculars, off-campus operations overseen by the institution. It applies both in person or over the internet. And it has language that it applies in a building owned or controlled by a student organization. The first kind of highlighted piece in red there is a significant change, that this sex discrimination, the scope of the proposed program or activity can occur under the school's disciplinary authority. So this is new, and this is kind of worth thinking through and whether it's worth commenting. But if an institution's code of conduct addresses interactions between students that occur off campus, that occur abroad, the institution would not be able to disclaim responsibility for addressing sex discrimination that occurs in a similar context. So one of the big changes that the department made is to kind of say, if you address disciplinary conduct over your in your code of conduct, you have to that you kind of bought it for purposes of Title IX. You have to address it for your Title IX in your Title IX policies. Apologies if there's a little muffled sound there. I'm hearing it as well. I'm going to try and fix that as soon as we can. So the code. So for institutions, again, another potential. Oh, there it goes. Point for institutions to consider: if you have a code that applies to off-campus conduct to address whatever it is, if you have that in your code under this proposed rule, you would also have to address sexual assault or violations of Title IX under that potential proposed conduct. So to the extent that universities or institutions want to be deliberate and consider whether they might want to revise that code, if this new rule goes into effect, one of the many decisions that schools will be making. The last piece to consider is this last aspect of the definition in red. So even if harassment occurs outside of the scope of a program or activity, and it still might have to be addressed if it has an effect inside the scope of the program or activity. So the department gives two examples in the NPRM. Student in a study abroad program alleges they're subjected to different treatment and grading based on sex in their study abroad program, and as a result, they lose their scholarship. So the different treatment, the alleged harassment, occurred outside the United States, so that piece wouldn't be covered, but because that conduct caused the student to lose their scholarship, which would be within the recipient's program, that potentially would be covered. And then the department also says students experience sexual assault at a nightclub by a third party and is experiencing emotional distress and can't attend classes. So Title IX in that case would would not obligate a grievance procedure because it really has no impact on the students. There's no connection to the school's education program or activity, but the institution would still be encouraged to provide supportive measures. And with that, I'll turn it back to Aaron.
Very good. Thank you, sir. So we thought it would be good after going through that section to maybe take a step back. If you're like me, this is a good time to take a deep breath. I will say just real quickly, first of all, that we've got our first secret word. So if you are in attendance, please make sure to hit one of those radio buttons. But while you're doing that, let me offer this up. So it's interesting because the Trump administration's approach, and I'm going to take it way up to 40,000 feet here, but many of you have heard me say before, if you listen into our presentation, I'm sort of a top-down learner, so it's helpful for me to think of things in terms of the big picture and then get into the more granular pieces. You know, from 40,000 feet, the approach the Trump administration took was to say, we're going to put a tighter box around what's considered Title IX sex discrimination, and even more specifically, Title IX sexual harassment. And there aren't going to be as many things that get inside that box, right? So you had a smaller box when it came to sex discrimination, right? Because we weren't including discrimination on the basis of sexual orientation or gender or stereotypes, all those other things. So that was tighter. And then even if you got inside that box, the real complicated stuff didn't get triggered unless somebody files a formal complaint, right? That's a huge piece of the Trump administration's construct, is someone has to file a formal complaint of a type of sexual harassment meets the definition of Title IX sexual harassment. That's current law. That's what you're dealing with right now, okay? So harder to be sex discrimination in the first place, even harder to qualify as sexual harassment, and then requires the filing of a formal complaint. However, if you file a formal complaint on campus right now, then the Trump administration has a very complex set of requirements that have to be satisfied, right? So you guys know if you get a formal complaint of Title IX sexual harassment, you've got all these trappings that, you know, live hearings and notifications and investigations, and you can't use the single investigator model, and you have to have all these conflicts of interest satisfied, you know, and then you've got cross-examination and technology, all that stuff, right? So what's interesting is this administration has changed things in that they've cast a much broader net up front, right? So that's all the Scott was just talking about. And if you're like me, when he goes through those definitions, you keep seeing that these definitions get broader and broader and broader, and you think, oh my gosh, and it starts to speed up your pulse. If you're someone at an institution who is contemplating, you know, the increase in volume of complaints and notices that are going to be captured here, and it will be. This administration is proposing a much, much broader net. We've got a broader definition of sex discrimination. We've got a much broader definition of, you know, what we're calling here sex-based harassment. We've got a broader idea of program and activity. So a lot more stuff is going to get captured. But this administration's procedural requirements, as we're going to go through here, we're about to turn the corner and start talking about procedure, are in many ways more streamlined. So the department is going to require you to act in a broader set of circumstances and address a broader range of reported conduct. But they are going to make it easier for you in many ways. This is my view, of course, but I think they are going to make it easier for you in many respects to address that conduct once it comes in. So you can do it in a more streamlined and efficient manner. Now, it's not going to be easy, but it's more efficient than the Trump administration's framework that you have to apply to formal complaints. So it's sort of a shifting, if you will, right? The Trump administration, you don't get as much stuff inside the box, but once you're inside the box, it's really complicated. Here, you're going to get a lot more stuff inside the box that qualifies as sex discrimination, but you will likely be able to address it in a more efficient manner once it's in. All right, so let's sort of move on and talk about the procedural difference. We thought a lot about how to capture this visually. I'm calling it a Title IX procedural waterfall. I'm sure you'll see other things from other places. But so in a minute, Stephanie's going to talk about this notion of notice, and that's under the new 10644C, and that really triggers the institution's obligation to do something. And, you know, under the current administration, you know, you have to have actual notice or knowledge, rather, and so the bar is higher. We just talked about that, right? It's a little harder to get in the box. Here, it's super easy, right? If the Title IX coordinator receives notice of conduct that may constitute sex discrimination under Title IX, they have obligations, right? So that's, and I want to note here, you know, it doesn't have to be sex-based harassment. It's just notice of conduct that may constitute sex discrimination. So that could be, you know, any of that stuff we talked about. Remember those early slides? I mean, that could be in counseling or financial aid or employment or sex-based harassment or sexual misconduct. Notice of any conduct that may constitute sex discrimination under Title IX, that triggers your obligation to do something. So that's that much broader net that's being cast out there, right? So then as we move down the waterfall, in response to a notice of possible sex discrimination, 10644 F through K lays out what a Title IX coordinator has to do. And they essentially, I'm going to call it an initial assessment and response. You can call it whatever you want. The department doesn't give it a particular label. It just says, this is the stuff, if the Title IX coordinator gets that notice, that they have to do, without regard to whether a complaint has been filed, much less a formal complaint, right? Without regard to whether a complaint has been filed or the alleged behavior involves sex-based harassment. So I just want to, this is an important concept because this is like the whole procedural flow in the proposed rule. It's really important to understand. If your Title IX coordinator receives notice of conduct that may constitute sex discrimination, you don't have to have a complaint. This notion of formal complaint has been totally taken out of the framework. It doesn't exist anymore. Complaint still exists, but you don't have to have a complaint. You don't have to have any alleged sexual harassment or sex-based harassment. It's just if you get notice of sex discrimination, your Title IX coordinator has to do the stuff that's in 10644. So, and this gives you an outline basically of the next few segments of our presentation. So Stephanie's going to talk about notice and what we're talking about and who has to give notice and when to the Title IX coordinator. And then I'm going to talk about the Title IX coordinator's responsibilities if they get that notice. But what if someone goes to the next step and files a complaint? Okay? So in response to a complaint of possible sex discrimination, the Title IX coordinator then has to initiate your, what I'm going to call universal grievance procedures. These are the grievance procedures, again, that have to be initiated if a complaint is received about any form of sex discrimination. So that could be sex-based harassment, that could be athletics, you know, a lack of equity in athletics, it could be any type of sex discrimination, right? Without regard to whether, again, the behavior involves sex-based harassment involving a student or anyone else. If you get a complaint, your universal procedures have to be initiated, right? Okay. And then if you get a complaint of possible sex discrimination that involves sex-based harassment against a student, right, or involving a student, I should say, because the student could be the respondent or complainant, then the Title IX coordinator follows both the universal grievance procedures in 10645 and these additional procedures in 10646. So I called it a waterfall on purpose because you're not, these aren't disjunctive. You're not doing either what's in 10644 or what's in, it's cumulative, right? You're moving down the waterfall. So once that notice is received, you go to 10644. If you then get a complaint, you have to not only do what's in 10644, you have to add what's in 10645. If you get a complaint that also involves sex-based harassment concerning a student, you add on what's in 106.46. So this is the structure that essentially has been laid out. And you can see it's totally different from the current structure that keys on whether or not you have a formal complaint that formal complaint concept, again, has been totally thrown out. And instead, we go notice to complaint involving sex-based harassment involving a student. And at each stage, you have to add procedures and there are additional requirements with which you have to comply. So what we're going to do now is we're going to start and talk about notice, then we're going to talk about 10644, response to notice. We're going to talk about 10645, response to complaint in your universal grievance procedures, and then we're going to talk about 10646 and the additional procedures an institution has to follow in response to sex-based harassment involving a student. And with that, Stephanie, I throw it to you.
Thanks, Aaron. As Aaron just mentioned, we are now going to talk about notice. And under 10644C of the proposed rules, there is language that obligates pretty much every employee at a post-secondary institution, with the caveat that they're not confidential employees, to notify the Title IX coordinator if they have information about conduct that may constitute sex discrimination under Title IX. Since some of the notification requirements depend on whether or not the individual who comes forward with the information is either a student or an employee, it's important that there's an understanding of whether or not that person is a student or an employee, and as that there may be overlap there, look to the primary relationship with the institution will help to define or describe whether that person is a student or an employee. I also want to note that this is a significant change, and for most schools, it will require training. However, we have worked with some folks who are in jurisdictions that already have these similar notice rules, and we have found that once the employees are trained on what their obligations are, this process is very manageable, and people know what they're doing and are able to get the information to the Title IX coordinator as required. So here there are 4 main buckets of employees and who have these notification obligations. First, we have the employees who can implement corrective measures. And these employees must notify the Title IX coordinator when the employee has any information from any individual about conduct that may constitute sex discrimination under Title IX. Next, there is the administrative leadership teaching or advising employees. And as you'll see here, these groups of employees have different obligations whether or not a student makes a complaint or an employee makes a complaint. So first here, if the student is the complainant, then the administrative leadership teaching or advising employees must notify the Title IX coordinator. However, if it's an employee that comes forward with conduct that may constitute sex discrimination under Title IX, then the Title IX coordinator, or then that employee can either notify the Title IX coordinator or can provide the employee complainant with information on how to contact the Title IX coordinator, so providing contact information, and also on information on how to report the sex discrimination. Finally, for all other employees who are not confidential employees, who receive these information about conduct that may constitute sex discrimination under Title IX, they must either notify the Title IX coordinator or they can provide the contact information and information on how to report the sex discrimination to the complainant. So there are a few areas within 10644 that provide for types of limited obligations, so where individuals really are not obligated to report the conduct. So first is when an employee complainant is the only person who has knowledge about conduct that may constitute sex discrimination. So in that instance, these requirements do not apply. Additionally, for confidential employees, earlier I had noted that the 4 buckets of employees applied to anyone who was not a confidential employee. However, for a confidential employee who is somebody who may engage in privileged communications or is deemed confidential for other reasons, they must, first of all, inform the individual who came to them that they are a confidential employee, and then they must provide the person who came forward with the information with the contact information of the Title IX coordinator, and they also must provide information on how to report the conduct that might be sex discrimination under Title IX. Finally, if the Title IX coordinator learns of sex discrimination or harassment that occurs at a public awareness event, that the Title IX coordinator is not obligated to respond unless the claim poses a serious threat to the health and safety of community members. To continue the conversation, I will hand it back to Aaron.
Thank you, ma'am. So you guys can see again, you start to think about what this administration is trying to accomplish. And, I mentioned earlier, I mean, they've broadened the scope of these definitions of sex discrimination, sex-based harassment, program and activity, because we want to capture lots and lots of conduct, a much broader range of conduct under the umbrella of Title IX. So the other thing you see now is they're creating a mechanism not only so that, that conduct would be captured, but also to try to make sure that it's actually getting reported to the Title IX coordinator so it can be addressed. And of course, the way you do that is by obligating institutions to obligate their employees to report this information to the Title IX coordinator. Stephanie mentioned just a couple of quick thoughts on this. I mean, the first is it's probably not a bad thing, candidly. I mean, you're already training your employees to try to report information like this to the Title IX coordinator. I mean, it's a little tricky now that they're obligated, but that's probably where you want these things to go anyway. And sometimes when there's optionality and someone's not actually obligated, then they decide not to, and they may decide to handle it on their own, et cetera, et cetera. Funneling all of this information to your Title IX coordinator, who is probably the most knowledgeable person on campus about how to handle it, is not necessarily a bad thing. And Stephanie mentioned, in our experience, we do have some clients that are in states that have state-level laws that effectively work the same way. And, we found, I mean, once we trained employees, we gave them little, cheat sheets to keep on their desk. And they said, if someone comes to you, a student or employee, with, concern about sex discrimination, here's what you should say. And here's the information who you should, to whom you should direct them. And then we also, in one case, made little laminated cards that they could put in their wallet for those who still have wallets, or maybe attached to their phone. Maybe the more modern approach would be to send them something that they can store in their phone. But at any rate, we gave them these tools, and I think a lot of employees actually sort of appreciated it and felt it calmed them, because I think a lot of folks who have awareness of Title IX also have uncertainty about what their role and responsibility is. And I think by giving them something and saying, this is what you're supposed to do, and here's the reference, and if somebody comes to you, these are the things that you should say, I think a lot of folks kind of appreciated that. And it did serve as just an efficient funnel, and then we just covered that in training. The other thing, though it's not required here, that we would often include on that information for employees is some information about confidentiality and confidential resources, because we wanted to make sure that employees, as soon as someone came to them, could help explain to that person whether or not they were a confidential resource, typically not the case, and what that distinction meant, and where they could potentially find a confidential resource on campus if that was something they wanted. But at any rate, this is all just to say we have had schools that have already been operating to some extent in a construct that is similar to this, and our experience has been that there are ways that can be done somewhat effectively. All right, so now let's talk about the Title IX coordinator's initial response. This is a repeat, but it's such a critical ID here. So under 10644F, a Title IX coordinator would be required to take certain steps upon being notified of conduct. That's it. That's the trigger. You're notified of conduct. And, of course, all these employees are now obligated to notify the Title IX coordinator or send people to the Title IX coordinator, right? So the Title IX coordinator gets notified of conduct that may constitute sex discrimination under Title IX, right, by an employee or any other party. And then, again, without regard to whether a complaint has been made, and I'm going to put complaint in quotes. We're going to define that term on the next slide, or whether or not anyone has requested that the institution initiate its grievance procedures. This is just any notification to the Title IX coordinator of potential sex discrimination. Okay. So what do they have to do? The law lays out, there's a lot, and we're going to cover all of it, but sort of the first thing that the law gets into is these 5 or 6 very specific things that the Title IX coordinator has to knock off. Of course, they have to treat complainants and respondents equitably. And by the way, this administration, I think, went out of their way at several points you're going to see in the process to try to strike a balance between complainant and respondent rights. As you know, that was a really hot topic. A lot of folks felt like the Obama era guidance swung a little too far towards complainants. A lot of folks felt like the Trump approach swung too far in the direction of respondents. I think this administration, if for no other reason that they want their Title IX rule to stick and not be killed in litigation, is trying to strike some level of balance, and you see that reflected in this proposed rule, right? So they specifically say you have to treat complainants and respondents equitably. You have to provide them, at least the complainant initially, notification implementation of the grievance procedures. And if a complaint is made, and again, we'll get to what that means on the next slide, if a complaint is actually made, you have to notify the respondent of the applicable grievance procedures and notify the parties of any available informal resolution process. Now, keep in mind, this is if there is a respondent. Aaron, what do you mean? How could there not be a respondent? Well, somebody could complain that the institution is actually discriminating on the basis of sex, not an individual. And if that's the case, it's the school, the recipient, if you use the parlance used throughout the rule, it's the school that is actually, in a sense, the respondent. But there's not some individual, so it changes a little bit when the complaint actually involves conduct on the part of the institution and the idea that the institution itself is violating Title IX. Supportive measures, here again, this is a concept that we've seen and it's been around for a long time, and that this administration is certainly not getting rid of it. And in fact, I think the differences between what we saw even under the existing Trump rule and here around supportive measures are not all that significant. You have to offer and coordinate supportive measures as appropriate to the complainant and respondent. And this administration and the proposed rule has been careful to strike that balance again and to include the idea that respondents might need supportive measures. In response to complaint, you have to initiate the institution's grievance procedures. So you have to first, the Title IX coordinator's got to tell them about the grievance procedures in any informal resolution process. And then if there is a complaint, then the Title IX coordinator actually has to initiate the grievance procedures. In the absence of a complaint or informal resolution process, determine whether to initiate a complaint on their own in the event that a complaint is not actually made. And then finally, take any other appropriate steps to ensure that sex discrimination does not continue or recur. Now, I'm going to keep saying this over and over because it's so important to understanding the procedural approach with this proposed rule. But please keep in mind, we are not talking about what a Title IX coordinator has to do if they get a complaint of sex-based harassment. We are talking about what a Title IX coordinator has to do if they receive a notice of potential sex discrimination. Big definition, right? Sex discrimination. Could be in athletics, could be in employment, could be anywhere on campus and in practically any form as long as it's in your program or activity. Okay. So let's just zero in on a few of these ideas real quickly. I mentioned that supportive measures, the approach hasn't really changed all that much. Here again, under the proposed rule, Title IX coordinator is available to offer supportive measures and should, as appropriate, to the complainant or respondent. I want to just skip down that, these can vary. The school has to be sure that as it approaches supportive measures, it does so on a confidential basis. I want to go to the third sub-bullet here, which is something that most of you will probably be interested in. So this proposed rule still says supportive measures that burden a respondent may be imposed only during the pendency of the grievance process. These measures must be no more restrictive than is necessary to restore or preserve the complainant's access to the program or activity. They cannot be punitive, right, or used for disciplinary reasons. So here again, this administration is trying to strike this balance and say, look, you can burden the respondent, but there are limitations around what type of burden you can put on the respondent, which is an approach that's not unlike what we have in current law. A school must provide a complainant or respondent with a timely opportunity to seek modification or reversal of supportive measures as well. So if you do put supportive measures in place that burden a respondent and the respondent feels like it's too much of a burden or the complainant feels like they're not getting the support they need, they also have an opportunity, a timely opportunity to seek modification or reversal of those supportive measures. But overall, this does not look unlike what you see in current law, and I suspect that this is not unlike what a lot of institutions are doing. Something else that, again, is somewhat similar, and I think this is positive, this administration still acknowledges that in some cases institutions would need the ability to act quickly on removal or leave. So the proposed rule would permit an institution to remove a respondent from the school's education program or activity on an emergency basis, and not unlike current law, to do so, and before you do so, you have to undertake an individualized safety and risk analysis, determine that there's an immediate and serious threat to health or safety, provide the respondent with notice and an opportunity to challenge the decision immediately following the removal. Scott mentioned earlier, and I will echo his prior comment, that it's important not only to comment about things that you think are problematic, which is extremely important and we encourage, but it's also important to comment about things that you think that this administration is getting right. So to the extent that you think sort of maintaining this approach around supportive measures and removal or leave makes sense, I would encourage you to consider commenting on that front. And with that having been said, let's talk about informal resolution, which is also provided for. And Stephanie, I'll kick it back to you.
Thanks, Aaron. So switching gears just a little bit here, another area where the proposed rule seeks to clarify some information that is in the current rule is on the topic of informal resolution. First, I just want to note that the informal resolution process can happen at any time prior to a determination of whether sex discrimination occurred, and no complaint actually needs to be filed in order for the informal resolution process to begin, but the process cannot happen, so informal resolution cannot happen if there are allegations that an employee engaged in sex discrimination towards a student, or if the informal resolution process would conflict with any applicable state, federal law. An institution is not permitted, though, to require or pressure the parties to participate in informal resolution. They must also get voluntary consent from the parties, and they are prohibited from requiring a waiver of the right to investigation and adjudication of a complainant as a condition of enrollment or continuing enrollment or employment or continuing employment or exercise of any other right. Interestingly, though, a school can decline to offer informal resolution even if a party wants it. And some reasons for that would be when a school determines that the alleged conduct might or would present a future risk of harm to others. Additionally, it's worth noting that there is an affirmative obligation for a Title IX coordinator to take prompt steps to ensure that sex discrimination does not continue or reoccur. This is specifically noted, and even though you may engage fully in the informal resolution process, the Title IX coordinator does have that obligation as well. So before initiating the informal resolution process, a school is required to provide notice that explains the allegations, the requirements of the informal resolution process, that any party has a right to withdraw and initiate the grievance procedures. Resolution through the informal process would preclude the parties from the grievance procedures. So if the parties do reach that resolution, the complainant could no longer then go through that grievance process. There's also a requirement to notify the parties of potential terms of what a resolution would look like, what records could be shared or what records might be maintained. Also, that information that's obtained solely in the informal process cannot be used in a grievance procedure. And finally, that the facilitator of the informal process could serve as a witness in the grievance procedure, and that that witness could be used for other reasons other than just solely what that informal, what was discussed in that informal process. So in the informal resolution process, the facilitator has some qualifications that are outlined in the proposed rule. And first, that facilitator cannot be the same person as the investigator or the decision maker in the school's grievance procedures, and that they cannot have a conflict of interest or bias either for the complainants or for the respondents. And they generally, need to, and we'll discuss this in a little bit in terms of training, but they need to be trained on bias. They need to be trained on other pieces of what acting as a facilitator looks like. Additionally, the informal resolution agreements, there are some terms that are outlined in the proposed rule that could be what's included in those agreements, one of them being restricting contact between the parties, or restricting that the respondent participate in one or more of the school's programs or activities or attendance at specific events.
Very good.
And with that, yep, back to Erin.
So here's your secret word. Now what we're going to do while you guys are looking at and hitting the radio button, we're going to turn into grievance procedures for all complaints of sex discrimination, sex-based discrimination. So remember back, to our waterfall, right? If the Title IX coordinator receives any notice at all of any sex discrimination, alleged sex discrimination, and that doesn't mean sex-based harassment, it just means any kind of sex discrimination, then they have to go through those things we talked about earlier, what I was discussing. And as Stephanie mentioned, informal resolution could be an option for resolving whatever it is that was alleged without regard to whether or not a complaint was actually filed. Now we're going to talk about what you do if you actually get a complaint, but just a reminder, we're talking about a complaint of any kind of sex-based discrimination. So along those lines, what we're going to do is we're going to refer to these as your universal procedures, and I'm sure people will come up with different ways to think about it. But, we really wanted to use that word universal because we wanted to emphasize this notion that these are grievance procedures that should be followed anytime somebody files a complaint of sex discrimination. That's not how the current rule works, right? The current rule actually, if you don't have a formal complaint of Title IX sexual harassment under current law, then schools are pretty free to be able to pursue whatever type of grievance procedure or framework they want to. The current rule really doesn't say a whole lot about what you have to do outside of formal complaints of sexual harassment. You still have to have grievance procedures for managing complaints of sex discrimination, but there's not a lot there. Here, the department is taking and proposing a totally new approach, right? It's what we said earlier. If you get notice of sex discrimination, you've got certain responsibilities. If you get a complaint of sex discrimination, now you've got this set of universal procedures. And again, that's for any type of sex discrimination if someone files a complaint. So pursuant to 10644F, we said this Title IX coordinator must initiate the institution's grievance, the universal grievance procedures in response to a complaint. A complaint, key idea here. So remember, we no longer have a formal complaint concept. That is out the door with this proposed framework. A complaint would include any, quote, oral or written request to the institution to initiate the institution's grievance procedures. So it's a pretty low bar, right? So someone comes to the Title IX coordinator, they say, I believe I have witnessed or been subject to a form of sex discrimination, any type of sex discrimination. If they say orally or in writing, I would like the school to initiate its grievance procedures, a complaint has been filed, full stop. So now you've got those obligations that the Title IX coordinator has to manage anytime they get notice of sex discrimination, complaint or no, plus, at this point, with someone having requested that the institution initiate its universal grievance procedures, the Title IX coordinator is now responsible for setting these universal procedures in motion. So again, it's a very low bar, right, in a sense, right? It's a larger box or a broader umbrella, however you want to think about it. Under proposed 10645, virtually anybody can file a complaint. I mean, it's really, again, pretty wide open. So, of course, the complainant, which includes a student or employee who's alleged to have been subjected to the alleged sex discrimination, or a person other than a student or employee who's alleged to have been subjected to the alleged sex discrimination, a lot of allegeds, and who was participating or attempting to participate in the school's education program or activity. So who might that be? I don't know. If you got a football game Saturday night and you've got 80,000 people in that stadium, well, that's a program or activity of the institution. You could have a lot of people there who aren't students or employees, but someone could be subjected to sex discrimination, and then they could ostensibly ask the institution to initiate its grievance procedures. That would be a person who's a complainant, if they were actually directly subjected to the alleged conduct, by the way, then they would be in a position where they could file that complaint. A parent, guardian, or other authorized legal representative of a complainant, right? A Title IX coordinator, or finally, with respect to complaints of sex discrimination other than sex-based harassment, any student and employee or third party participating or attempting to participate in the school's education program or activity. So just to draw a distinction between the first bullet and the last bullet here. Remember, the first bullet, we're talking about individuals who have been subjected to the alleged sex discrimination. So they're actually the complainant. In the last bullet, we're not necessarily talking about the individual who is subjected to the sex discrimination, right? We're saying someone could file a complaint, right, with respect to, as long as it's not sex-based harassment, it could be a student or employee or a third party participating or attempting to participate in the program or activity. So it's a low bar. We're talking about a lot of stuff that could initiate this process. Okay, so what do you have to do? What has to be a part of these universal grievance procedures? Equitable treatment, again. So these are things that have to be part of your universal procedures under the proposed revisions to the law. Conflict of interest. So this is really important. So your procedures have to require that any person designated as a Title IX coordinator, investigator, decision maker not have a conflict of interest. However, big however, the decision maker may be the same person as the Title IX coordinator or investigator. So this administration is saying you can use a single investigator model, right? At this stage, you can use a single investigator model to manage all these processes. So I mentioned earlier, you know, they're casting a much broader net. We're going to have a lot more, a higher volume potentially of the types of things that can get to your Title IX coordinator. But I also mentioned that I think this administration is potentially giving you more efficient opportunities to manage some of these complaints. And one of the ways they're doing that out of the gates here is to make the single investigator model available, okay? You have to include a presumption that the respondent's not responsible for the alleged conduct. Okay, that's consistent with current law. Establish reasonably prompt timeframes, but we don't have specific timeframes like we saw back under the Obama administration. So, you know, we've got, first of all, some additional deference to the respondent, right, in this version, and we've got the department backing off a little bit and not requiring specific time frames. You have to take reasonable steps to protect privacy, require an objective evaluation of all the relevant evidence, provide that credibility determinations not be based on status as a complainant, respondent, or witness, and finally exclude specific categories of evidence and questions seeking that evidence. With regard to exclusions of evidence, you know, I would say this is fairly consistent with the approach under current law. The only, you know, things you would expect, exclusion of privileged evidence or treatment records. There are some nuanced differences, I think, in evidence relating to sexual interest or prior conduct. I'm not going to get into that in detail, but if that is an area of particular interest to you, I would suggest that you look that up. That's in 10645 is where you'll find that information, compare it with the current rule, and that may be a place where you want to be thoughtful and comment with the department. Notice of allegations. So remember, if we've got a complaint of sex discrimination, not necessarily sex-based harassment, any kind of sex discrimination, but a complaint has been filed. Someone has asked us to initiate the grievance procedure. So you have to give notice. And what's that notice have to include? Well, it's got to talk about the grievance procedures under 106.45, which is the universal procedures, and if applicable, 106.46, and that's that last level that involves sex-based harassment concerning or involving students, either as a respondent or complainant, as well as any informal resolution process. So, you know, they're just saying your notice has to describe all this stuff. You also have to provide notice that includes sufficient information to allow the parties to respond to the allegations, including the identities of the parties if available, alleged sex discrimination, like what's being alleged, and the date and location of the alleged conduct to the extent, again, available. And in a statement that retaliation is prohibited. By the way, we always, right now, in anything we draft for clients, I mean, we always include a statement that retaliation is prohibited in every written communication throughout the entire process. We continue to include that sort of as the final piece, and that's always a good idea. If during the investigation the school decides to investigate additional allegations, the proposed rule expressly states that they would have to provide the parties with an updated notice. By the way, you should already be doing that too, right? Anytime during an investigation, if you uncover additional things that would essentially be allegations, you need to update your respondents so they understand all the allegations that will be considered. Universal procedures, the optional dismissal is included in the proposed rule. So this is a little different. Remember, under the current rule, you have some optional dismissal possibilities, and then you have some required dismissal possibilities. So, you know, if you determine that the sexual harassment under current law isn't, quote, Title IX sexual harassment, you are obligated to kick it out of your Title IX process. That concept no longer exists, right? I mean, if you're here, you've had your Title IX coordinators receive notice of some form of sex discrimination in this broadest sense, right, then they have to do certain things, and then if we got a complaint filed, you're here. There's no kicking it out, right? Your policy is going to cover it. But there are some reasons why you could choose to dismiss. School's unable to identify the respondent, or the respondent's not participating any longer in the school's educational program or activity and not employed by the school. So, you know, and we see this happen all the time. Some respondent, student, or employee will either go off and cease to be employed, or, you know, graduate, no longer be a student, or you can't find them, nobody responds. So, you know, here the proposal is that you would have some flexibility as a school to move on in that circumstance, which is probably positive. And by the way, this may be another place where you want to comment that you support this idea. I think it is good for schools to be able to dismiss complaints in certain circumstances. If the complainant voluntarily withdraws some or all of the allegations, and the school determines that without the withdrawn allegations, there would no longer be any conduct at issue that would represent sex discrimination, or if the school determines that the conduct alleged in the complaint, even if proven, would not constitute sex discrimination. And that happens, right? Sometimes somebody will come, in fact, I think it happens quite a bit. Someone will come to your Title IX coordinator with a complaint that may violate a student code of conduct or otherwise be something the school wants to address, but it's not sex discrimination. It just needs to be addressed under, you know, your standard code of conduct or elsewhere, but it's not sex discrimination covered by Title IX. So that would be another basis for an optional dismissal. If you do pursue an optional dismissal, the proposed rule would require that you follow certain procedures. I won't go through all of these completely, but it's nothing that would surprise you. You got to provide notification of the dismissal. You have to provide an appeal right, and you also have to be ready to provide supportive measures or otherwise engage in remediation. So in other words, just because you optionally dismiss something doesn't mean there's still not an opportunity to remediate some sort of concern around sex discrimination. Potentially, if you dismissed it because the respondent disappeared, that doesn't change the fact that sex discrimination occurred, and there still might be good reasons to try to address that. All of this is probably pretty consistent with what you already do. Consolidation of complaints, again, this idea exists in the current rule. This is something that the proposed rule would permit as well. I don't think there are any surprises here. The only place where it can get a little sticky is if you've got a situation where you've got multiple complaints or multiple respondents. And if you look at the second bullet, for example, if one of the complaints to be consolidated as a complaint of sex-based harassment involving a student complainant or student respondent, then you have to be thoughtful about, even if you're going to consolidate them, you got to make sure that the piece that involves the student, you're still giving them these extra procedural protections required under 10646. So, consolidation can be a little tricky, but the law as proposed would clearly allow it. And again, this is something you probably want to support. I mean, I think in a lot of cases you would want to have the flexibility to consolidate complaints where it makes sense to do so. All right, let's talk about in the investigative stage and the determination stage. And keep in mind, we're not talking about investigations of sexual misconduct. We're talking about investigations of any notice of sex discrimination where the complainant requests the grievance process. So this could be sexual misconduct, meaning like sex-based harassment, or it might not be. It could be inequity in athletics, right? Or in, a concern around unequal pay among employees or anything along those lines. Okay, if you are conducting your investigation, you have to ensure that the burden is on the institution. Sometimes that surprises people, but remember, Title IX governs schools, not complainants and respondents. And what it says is schools have to remediate and address sex discrimination, right? So ultimately, the burden to conduct the investigation and resolve things is on the school, not on the complainant or the respondent. There's, again, an equal opportunity requirement for the parties involved in the investigation. A school its policy has to provide that it will review all evidence and determine what evidence is relevant. You have to provide each party with a description of the relevant evidence. That doesn't necessarily mean that you have to provide them all with copies of all of the relevant evidence. And for the lawyer types, this could be a pretty significant change from what you're doing right now to address formal complaints of Title IX sexual harassment. And finally, you have to provide a process that enables a decision maker to adequately assess credibility of parties and witnesses. But keep in mind, single investigator model is available. So this could be something that your Title IX coordinator is handling entirely, both with regard to sort of the supportive measures and things along those lines, conducting the investigation and the determination as well. Speaking of determinations, again, for your universal procedures, there are a number of things that have to be included in your procedural documentation. You have to use the preponderance of evidence standard unless the school uses the clear and convincing standard in all other comparable proceedings. So interestingly enough, even this administration is keeping the door open potentially for the clear and convincing standard, although candidly, we don't have a single client, and I'm not sure I know of a single school that uses clear and convincing in Title IX proceedings. I'm sure they're out there, but it is our impression that the vast majority of you are using the preponderance of evidence standard. You have to notify the parties of the outcome of the complaint and the process, as you would expect. As appropriate, Title IX coordinator has to implement remedies for complainants or other impacted persons. There have to be procedural protections. And then finally, and I just wanted to highlight this, I'm going to read this to you in its entirety. Not discipline a party, witness, or others participating in a grievance process for making a false statement or for engaging in consensual sexual conduct based solely on the school's determination of whether sex discrimination occurred. Why did Aaron read this entire sentence, which is almost verbatim out of the rule? Here's why. Because I cannot figure out what this means. And you know, I think I know what it means, and we reviewed the preamble, and it seems to be that the intent is sort of as an anti-chilling provision, right? So the idea is not to chill folks from participating in the grievance process because they're afraid they would otherwise be disciplined for some type of conduct. But I think it is horribly written, and I'm reading it in full as an example to you that of the type of language that you might want to comment on. Here's my point, succinctly made. Sometimes these proposed rules, there will be language that doesn't make sense. And I encourage you, if you read something and it doesn't make sense to you, and you read the preamble and it still doesn't make sense, that's a great opportunity to comment to the department and say, this does not make sense, and schools aren't going to be able to figure it out. So rewrite it in the final rule so we can all understand exactly what you mean. Finally, in your universal procedures, you do need to have language, a couple of concepts managing sex-based harassment. And this is a really important thing I want to highlight here. So this last section that Scott's going to go through, which involves additional grievance procedures for sex-based harassment, it's only sex-based harassment involving students. So keep in mind, if you have allegations of sex-based harassment that only involve students, only involve employees. Let me state that again. I want to be very clear. If you have allegations of sex-based harassment that strictly involve employees, then that would be managed under your universal procedures, right? The stuff that I just went through, which means, for example, under a single investigator model, right? And or under informal resolution. Now, you do have to, on the one hand, anything you do for employees that involves an allegation of sex-based harassment has to comply with these Title IX requirements for universal procedures if this becomes law. On the other hand, I just want to be clear that all the extra stuff Scott's going to go through would not be required, right? So reflecting before we pick up with Scott and we got our next secret word, we've got this extremely wide range of matters that are now potentially covered, right? Broadened definition of sex discrimination, sex-based harassment, et cetera, anything that gets funneled into your Title IX coordinator. And if a complainant simply says, I want to go through the universal grievance procedures, that's a complaint. That's all that has to happen. There's no formal complaint concept anymore. But when you're looking at what's required of this process, single investigator model is permitted, informal resolution is permitted, and I don't know if you guys noticed, but there was nothing in here about hearings. Let me say that again. There's nothing in the universal procedures that requires that you hold a hearing, which means if you had a complaint of sex-based harassment that only involved employees, there's nothing that requires a process that includes a hearing, advisors, cross-examination, none of that. You could devise a single investigator model process for managing not only all other non-harassment sex discrimination complaints, but also your complaints of sex-based harassment involving your employees. No hearing is required, nor is there any requirement for an appeal, right? It's only if you have sex-based harassment that involves a student that you get to this final level of procedure and the waterfall, which Scott is about to go through. But I just want to highlight again the points we made earlier, that you've got a lot more that's likely to come to your Title IX coordinator, and the bar is low for having to initiate your universal grievance procedures. But this administration is suggesting that for anything short of sex-based harassment involving students, those procedures can be pretty streamlined, and it can be handled by just your Title IX coordinator or a single investigator, and you don't have to have a hearing or advisors or appeal or any of those things that are part of the process. So it's a little bit of a trade-off. Scott, let's see. Let's do the next secret word, and then take us through your next round of procedures, sir.
Sounds great. Thank you, sir. Did we hit the secret word already?
There it is, right there.
Tigers, yes. Yeah, so Aaron, yeah, I hope everyone believed me when I said it was a little broader, a lot more things to cover. But to follow up on your point, as we're going to go over as well while you're looking at the secret word, the procedures for sex-based harassment for students are certainly more involved, but still add a lot of discretion for institutions. So interesting choices from the department here as well. Okay, let's jump in. Right, so as Aaron mentioned, we're at the final stage of the waterfall. This only comes about with sex-based harassment that includes a post-secondary student complainant or post-secondary student respondent. This 106.46 needs to be read in conjunction with 106.45. There are cross-references between the two, and we're going to go through a little bit, but certainly everything in 106.45 applies. This is just additional icing kind of on the top for sex-based harassment that includes a post-secondary student. The department goes into why they kind of made that in the preamble, or made this distinction in the preamble if you're interested. If it involves both a student employee here, it's a fact-based inquiry. You look to the primary relationship with the institution, whether the alleged conduct occurred in the scope of employment. But if it's closer to a student, these procedures would apply. Closer to an employee, your universal procedures under .45 would apply. Written notice, this should be familiar for those current procedures that are in place now. So under this additional added layer, written notices of allegations, dismissals, delays, meetings, and hearings. The written notice has to include all information under .45C. Again, we're reading these in conjunction, allegations with sufficient time to prepare, presumptions that the respondent is not responsible, opportunities for the parties to present relevant evidence to a trained impartial decision maker, advice of choice, access to relevant evidence or investigative report, and if applicable, a provision of the code that prohibits false statements. So this is very similar. A few differences because the proposed regulations, as Aaron said, get away from this formal complaint requirement. These notices are provided upon the initiation of this grievance procedure, if applicable, and also this new concept of written delays. So if the institution has a legitimate concern for safety based on an individualized risk analysis, not mere speculation, they're permitted to delay this notice being provided. With dismissal, again, we're just adding on to the dismissal aspects in the universal grievance procedures. Here, if it's under 106, if the dismissal is based off of a standard in 106.45D1, for those of you that don't have a memory of what I went through, that's when the recipient's unable to identify the respondent's not participating, the complainant voluntarily withdraws a complaint, or the conduct alleged if proven will not constitute sexual harassment, you get simultaneous notice. If the complainant is dismissed based off of the complainant's voluntary withdrawal, meaning that without the withdrawn allegations, the conduct alleged could not be proven as sex discrimination. That voluntary withdrawal has to be obtained in writing. The investigation, again, looks fairly similar to kind of what we have here now: written notice of date, time, location, participants, and purpose of all meetings, interviews, hearings with sufficient time to prepare. Same opportunities for advisors. Advisor restrictions are permitted as long as they're equitable. Same opportunity for other individuals to participate, so parents that want to show up at the hearing as long as equitable. Interesting piece about expert witnesses. So the use of expert witnesses is up to the institution. So basically the department's interesting language in the preamble stating that expert witnesses may introduce delays without adding meaningful benefits. So in the department's decision, providing the recipient here, so the institution, flexibility is the best way to do it, but that is an important distinction here. Again, equitable access to evidence or a written report and reasonable opportunity to review and respond to the report. Again, here, there's no obligation for a live hearing under these department procedures. So depending on if you are going to institute a live hearing, that reasonable access could look different. And basically, again, with these cross-references, compliance with this provision, 106.46E6, would satisfy the requirements of a corresponding provision in the universal procedures. So the department's trying to make things a little easier. Did I skip one? Investigation. Credibility. So both parties must have access must have a process to adequately assess the credibility of parties and witnesses. And this is important. To the extent credibility is both in dispute and relevant to evaluating one or more of the allegations under sex-based harassment. So the department here is saying there must be a process to have credibility. They give you a couple options for what that'll look like, but only to the extent credibility is in dispute and relevant. So the department's very clear that to the extent under these rules that credibility is not in dispute or not relevant, these processes might not need to be put into place. Decision makers have to have the ability to ask questions to parties and witnesses during a live hearing or individual meetings. Again, the regulations kind of make clear that institutions can choose your own adventure here and have either these individual meetings or a live hearing. And if it's a live hearing, there are additional procedures that we're going to talk about, but the cross-examination requirements are kind of the same as the current rules. It has to be through an advisor, permitted but not required. Institutions can allow decision makers to ask questions with parties proposing potential questions. The decision maker here, again, in these procedures, if credibility is an issue, if issues of credibility go to the decision maker, it must determine whether that proposed question is relevant and not otherwise impermissible prior to the question being posed, and must explain any decision to exclude a question is not relevant. The department here is clear that unclear or harassing questions are not permitted, and reasonable rules of decorum, again, are permitted if equitable. Decision makers here cannot rely on a statement that supports a party's position if that party does not respond to questions related to their credibility. So again, if credibility is at issue and the individual does not respond to statements about credibility, the department cannot rely on those statements. This is similar to a current rule actually vacated by the Victims' Rights Law Center versus Cardona case, prohibiting decision makers from relying on statements who don't submit to cross-examination. And again, similar to current rules, decision makers can't draw an inference about whether sex-based harassment occurred based solely on a party's or witnesses' refusal to respond to questions about their credibility. So just one quick note, we spent kind of a lot of time, or not much time here, with the possibility of live hearings. Erin and I were talking previously that our previous presentations were so focused heavily on kind of the live hearing and what's required, and here the department is kind of giving institutions the options. There is a section of the rules about if institutions are going to have a live hearing, some of the familiar requirements must be there. You have to have parties either physically present or apart with technology and able to see them. You have to create an audio or visual recording or transcript and make parties available for inspection or review. So even though you're not permitted by these rules to have a live hearing, question for each of your institutions whether that is a good idea, and to the extent that you want to, you're able to and want to move forward with that. Again, certain public institutions and certain circuits, the Sixth Circuit after the Baum case, must have certain procedures with cross-examination in certain circumstances. Institutions could decide that the live hearing is the best way to make a defensible process. Here, all we're saying is the department is giving institutions the option about whether to have that hearing or not. Written notice of determination after either the live hearing or the investigation must include a description of allegations, information about policies and procedures, evaluation of relevant evidence, sanctions, and the appeal procedures. The determination is final upon the result of the appeal, or if an appeal is not filed when that is no longer timely. And last, institutions have to provide an opportunity to appeal based on procedural regularity that would change the outcome of the case, new evidence not reasonably available that would change the determination, conflict of interest or bias, or any other bases offered equally for the parties. And with that, I'll throw it back to...
Hey, Scott, yeah, to Stephanie, I think. But Stephanie, before you kick off here, and I know we got 3 more sections here we want to get through, but I do just want to comment briefly and sort of echo a couple of things Scott said to make sure that it really has sunk in for folks. I mean, and it ties back to one of our comments from earlier in the presentation. But again, it's this idea that we've got so much more that's being captured here and that institutions are going to have to manage. But for all complaints that you receive that don't involve allegations of sex-based harassment, including a student, either as a respondent or complainant, you can run a single investigator model, at least under these proposed rules. Now, and this is a really important point Scott just made, you know, it's possible you could have court cases that impact you, federal or state. You could also have even municipal laws that you have to contend with, or state level laws. So, you know, we're just talking about the bar that the feds would be setting, right, around Title IX. But the fact remains, assuming you don't have some other, you know, state law or court case that's applicable to you, what we're basically saying is outside of those sex-based harassment complaints involving students, everything else could be managed with without a hearing, without an appeal, with a single investigator model under this proposed rule. And even where you have complaints involving sex-based harassment that includes a student as a complainant or respondent, you still could run a process in theory that doesn't even involve a live hearing. So, you know, it goes back to the comment earlier about having it. Now, you may not want to, by the way. You may decide that you want to, not only because a state or a court requires it, but you also may just decide for certain matters you really want an independent adjudicator and you want to run a hearing for purposes of, you know, sort of protecting the institution and ensuring a quality process, et cetera. But it goes back to that idea that we're casting a broader net. A lot more is going to come in, but the department is giving you a process that is really relative to the formal complaint process you're dealing with right now, quite streamlined. I mean, it is extraordinary that when we did our webinar on the proposed rule from the Trump administration, we spent half of it talking about hearings and cross-examination and advisors. And here, those concepts are only in a small way even present in the proposed rule. So it's a pretty radical shift in that regard. And if you like it, you ought to comment on it. And if you don't like it, you ought to comment on it. All right, Stephanie, take it away.
Yep, thanks, Aaron. So moving to the topic of training, which is one that I personally love, I am going to go over what the proposed rule says in terms of training. And I do want to start off just by noting that this is sort of consolidating areas within the current rule to really make clear which specific roles need to be trained and what that training needs to look like. So first of all employees need to be trained, and they need to be trained on the school's obligation to address sex discrimination in its education program or activity, the scope of conduct that constitutes sex discrimination, and that includes the proposed definition of sex-based harassment. And then also they need to be trained on the applicable notification and information requirements that we discussed earlier today. The proposed rule does go on to expand to discuss specific employees. The first group of specific employees are investigators, decision makers, and other persons who are responsible for implementing grievance procedures or have the authority to modify or terminate supportive measures. That specific group, so they need to be trained on the school's obligation to respond to claims of sex discrimination. They need to be trained on the grievance procedures. They need to be trained on impartiality, avoiding prejudgment, conflicts of interest, and bias. As you may have noticed, that is really something that they seem to really be hitting on here, and making sure that all of these proceedings and processes are free of bias. And also, they need to be trained on the meaning and application of the term relevant in relation to the question evidence, the types of evidence that are impermissible regardless of relevance. So under the grievance procedures. The next sort of, the next group or the next types of employees that need to be trained are facilitators of the informal resolution process. I keep wanting to say informal resolution process. And they must be trained on the rules and procedures of that process, again, especially with impartiality and bias. And then finally, the Title IX coordinators need to be trained on their specific duties, and that training includes anything that's necessary to ensure compliance with Title IX. Moving on, shifting gears to retaliation. So for the non-lawyer folk out there, you may be surprised to hear that Title IX, the statutory language, does not contain a prohibition on retaliation. And although it's not explicit, the Department and the Supreme Court have long interpreted Title IX to prohibit retaliation. As such, the proposed rule does address retaliation, and they are specifically addressing retaliation here. They have provided a specific definition. I am not going to read to you all of the text that is on the screen here, but generally it includes intimidations, it includes other type of discrimination for people who are participating in any of the Title IX processes, or somebody who brings a complaint, anything like that, or grievance procedures. Additionally, the proposed rule provides a specific definition of pure retaliation. This is to help clarify pure retaliation, as the Department has indicated that this is something that they're aware of and has been a concern for individuals. And that is defined as retaliation by a student against another student. It's pretty straightforward, but just important to note that it is part of this proposed rule. And so the goal is to address the inadequate language that came from prior regulatory language, and really just define what retaliation means, including pure retaliation. So there is a strict prohibition on retaliation, and the proposed rules provide that a school must prohibit retaliation. And when a school does receive information about conduct that could be retaliation, the school is obligated to comply with those requirements we discussed earlier in 10644. You may notice that the word retaliation actually is not in that part, so it mostly is for the purpose of ensuring that the school is working to combat this sex discrimination, including retaliation. The proposed section 10671 provides two specific examples of retaliation. One of them is initiating a disciplinary process against a person for a code of conduct violation that does not involve sex discrimination, but arises out of the same facts as a complaint. And that for the purpose of interfering with the exercise of any right or privilege secured by Title IX. Additionally, the second example is pure retaliation, so that retaliation by a student against another student. It's also just worth noting that this proposed rule takes out an affirmative statement that an exercise of the rights under the First Amendment is not retaliation. This statement that that would not be retaliation, the department feels is redundant, as this is provided earlier within the current and proposed rule, and there's also a history of the department enforcing Title IX consistent with the protections of the First Amendment. And then once again, shifting gears, this proposed rule provides a really interesting focus on pregnancy, marital status. However, here we're going to really just look at pregnancy, as this seems to be one of the bigger sort of changes in this proposed rule in this specific topic on pregnancy and marital status. So what's really interesting is in the commentary of the proposed rule, they discuss a lot about how other laws have protected pregnancy, childbirth, and related pregnancy conditions, and these are the Pregnancy Discrimination Act. The EEOC then reinforces this in their guidance from 2015. Additionally, other laws have provided employees with private lactation spaces and reasonable break times for that. And here in the proposed rule, you'll see that they sort of leaned in on this history of laws and guidance, and worked from that to make some changes to in their words, to continue to fight this sex discrimination. So in the proposed rule, it's clear that a school cannot adopt policy, practice, or procedure concerning a student or an employee. There are two different sections. One applies to students, one applies to employees. That, current, potential, past, about parental, family, or marital status that treats students differently on the basis of sex. Generally, a school cannot require a certification to participate in its programs unless that certification is required from all students. Just briefly, sometimes in order to participate in certain activities, you may be inclined to ask a pregnant student to provide certification that they can participate in that activity. However, here it seems to be that that certification cannot be requested unless you are requesting it from all students. So the proposed rule does clarify that these protections are both for pregnancy and pregnancy-related conditions. That is consistent with those other laws that I discussed a little bit ago. Pregnancy can be based on a reasonable belief that the individual is pregnant, and this is very broad. And this reasonable belief is enough even if later on the individual finds out that they were not in fact pregnant. Additionally, other things, you cannot take into account a primary wage earner if that information is used discriminatorily. And there is affirmative obligation to provide students with information, pregnant students with information on how to contact a Title IX coordinator if they do come to you and let you know that they are pregnant. So while pregnancy within itself is not considered a disability, there are pregnancy-related conditions or other, pregnancy issues that can arise that can be, considered a disability. The proposed rule does indicate that these types of conditions should be treated the same as any other temporary disability. And the proposed rule is very clear that affirmative steps need to be taken to allow for equal access of pregnant students. In order to do that, a school does need to inform students of their prohibition on discrimination based on pregnancy, that the student has access to reasonable modifications, which I'll discuss in a minute, and that they can have access to comparable or separate programs, a voluntary leave, a lactation space, and inform the students of the school's grievance procedures. So just quickly, I did want to just hit on these reasonable modifications as it's an important part of this prohibition on discrimination based on pregnancy. So reasonable modifications can be given to a student if they're needed. They must be provided if they're needed. They need to be considered on an individual and voluntary basis. So an individualized assessment has to go into that. This is true unless the school can demonstrate that making the modification would fundamentally alter the school's education program or activity. So they must be considered unless there is this undue hardship. And a fundamental alteration is a change that's so significant that it alters the essential nature of the school's education program or activity that is consistent with what is under the ADA and Section 504 as well. So the reasonable modifications must be implemented by the Title IX coordinator, who also has to document them. The proposed rule does provide examples of what these reasonable modifications may look like, and here I have a number listed. They include breaks during class, or to express breast milk, intermittent absences, changes to schedules, online learning. There's a number of other reasonable modifications as well, but those are sort of the main ones, or some of the main ones. And then finally, the proposed rule also addresses lactation time and space to provide to both students and employees, which is definitely a new concept that is added in with this proposed rule. And I believe, yep, we have just your fourth secret word here. It is dinner. Give you a few seconds to get that in.
Very good. And I can't believe that timed out the way it did. I'd like to say we planned that. So with about 3 minutes left. So I'll give you just a couple of more seconds to look at the secret word here, and then we'll click through a handful of resources, and then we will open it up for questions. And like I said, we're going to stick around. I don't see hundreds of questions, so I think maybe we can get to the handful that we have, which is good, and then we'll call it. So moving on just real quickly, resources. I mentioned at the outset that we have this Title IX timeline. Those of you who've tuned in with us know that we like to do these. So it goes all the way back. It's a 4-slide timeline, starts with June 1972. When you see the links, so if you click on those, unless a link has changed recently, you should get the underlying Supreme Court opinion or the guidance from the department, et cetera. But again, we start back in 72. We take you through the Obama era here and the guidance, and then the Trump administration, their rescinding of the Obama era guidance, the Bostock opinion, their new rule in 2020. And then finally, here's where we are right now. You'll see July 2021. We also include a link to the Victim Rights Law Center Cardona case. And then finally, July 2022, the unofficial version of the new Title IX rule if you don't already have a copy. And as soon as we get a Federal Register with the official version, we'll add that to the timeline. I do want to highlight, we said it multiple times, this is a proposed rule. Keep in mind that actually, let's go, I think it might be on the prior slide on the training. You know, the department published its proposed rule on Title IX in November of 2018. That was the Trump administration. And I just want to highlight, it didn't get its final rule out until May of 2020. There was a 2-year gap between when that proposed rule came out and the final rule hit, and there were 120,000 comments received in between during the comment period. I don't think you're going to see a 2-year gap here, but I do want to highlight that this is a proposed rule. We got a 60-day comment period. It is still a controversial issue. There could be 75, 100,000 comments the department receives. They'll have to process all those, write up a final rule, and get that published in the Federal Register as well. That could be months out. Why I point this out and make a deal out of it, because in the interim you still have to comply with the current Title IX rule that's on the books. So I don't think you're going to see a new final rule, you know, next week or next month. It's going to be months from now. In the interim, please make sure that you're up to speed on the current rule. And if you are not or would like some assistance with compliance, we have a training series. We did a 6-part training series. It's almost 2 years old now. We did it in 2020 after that the Trump era rule came out, but it covers all different aspects, and it's actually designed for folks who are helping administer the Title IX process, and you can post it to your website if you like as part of your training materials. The other thing I'll just note, please keep an eye out. We have a blog. We write about stuff all the time. There's a lot of action happening, not just around Title IX, but as you all know, the department just released a new proposed regulatory package, I think yesterday, on a number of issues, and we expect them to keep coming. This webinar, like all of our webinars, are available free and on demand. If you thought this was helpful, send it to your friends and neighbors. And then finally, we occasionally do white papers and things of that nature, and we usually post them on our blog. So if you're signed up for our blog, you'll see it and can check it out. And lastly, we're not your lawyers unless we're your lawyers. Okay, so let's look at questions. Scott, I have the first one here. I'm going to pitch to you. We've got about 10 minutes, and I think we can get through most of these unless we get a bunch more. Would the proposed rules cover failure or refusal of a professor to use preferred gender pronouns of a student? What do you think, Scott Goldschmidt?
It could, very possibly, and as if people following this, this has been a hot potato past administrations. The Obama administration's guidance in 2016 was yes, this was covered in Title IX. By Title IX, the Trump administration in a few memos said that this is not covered by Title IX, and now with Bostock and the explicit inclusion of gender identity as a category of sex discrimination. It could. I expect this to be litigated, and this is not the last word on it. The preamble does not explicitly call this out. It says, but it does say that sex-based action that results in more than de minimis harm to an individual could constitute prohibited sex discrimination. So I think this very possibly could be covered under the new Title IX rule.
Yeah, agreed. I guess there might be some question as to whether it constitutes sex-based harassment, and that might get into the question of, is it objectively, subjectively severe or pervasive, and you'd have to kind of go down the road and do that analysis. But yeah, and it's definitely going to be no doubt a question that will receive a lot of ink, I think. Okay, since it can be difficult to investigate conduct that occurs off campus and outside the school's program or activity, can the school meet its obligations? And we're talking about if this proposed rule becomes a final rule, and looks like it does now, just to be clear. Could the school meet its obligations by addressing these types of complaints with supportive measures? Interesting. So I guess it would depend. I mean, we really don't know in this hypothetical what conduct's being alleged, right? But let's just assume for the sake of the question, Scott, that we've got some sort of, something that might be sex-based harassment, right? Like a sexual misconduct that occurred. This says off campus and outside of the school's program or activity. I guess if it were technically as a matter of law, under the new law, outside the school's program or activity, then you would have to ask whether or not it was somehow impacting the school's program or activity. If it were both off campus and outside the school's program or activity and beyond the reach of their disciplinary authority, I mean, it might actually not be covered. Is that fair? I think I got that right.
Yeah, I think a lot to unpack here. Right, and I think the questioner might be asking about the scope of the disciplinary code as part of the new definition of program or activity. So the question for institutions could be, the first one is this off-campus activity covered by your disciplinary code? If the answer is yes, the department's kind of said you bought the disciplinary conduct piece, then you're stuck with the Title IX aspect too, and you couldn't get away with just grievance procedures if it's supportive measures, as the question said. If there is if it's truly outside and there's no connection to the program or activity, it doesn't affect it at all, then it would be outside the scope of Title IX, and the department would encourage supportive measures.
Yeah. I mean, you could always, if everybody agreed and you considered it covered, let's say you said, well, even though, it's outside our program activity off campus, but we think it's otherwise, something we've got to deal with, you still have informal resolution that might be available if everybody agrees, and the nature of the misconduct would allow for that, et cetera. Or you could still have a single investigator approach that might be a little more streamlined. I do want to comment, Scott has mentioned this notion of your disciplinary, your code of conduct, sort of the reach of your own code of conduct and scope of your disciplinary authority. And we've been talking about this. I mean, it's really interesting because I think for a long time schools have sort of erred on the side of having codes of conduct that give them a lot of discretion. So they say, well, if you're out there and you do something that reflects poorly on the institution or could impact people, the institution's reputation, et cetera, then you're subject to our conduct, and we would be able to take action. And the thinking there is, in that case, it's probably to the institution's advantage because you want to be able to reach out and take action against a student. I mean, we were talking about this. What if they're home for spring break and they get in a bar fight? And you might say, well, maybe we're a faith-based institution, or maybe our code of conduct just says it's a general matter. Anything you do that reflects poorly on us, we reserve the right to take disciplinary action. But now the problem is if you've constructed your code of conduct in a way that is that broad, in theory, if that same bar fight occurs, because you are claiming that you have the ability to exercise disciplinary authority in theory over that bar fight, because it may reflect poorly on the institution, you may also have captured it, as Scott put it, you may have bought it for Title IX. So I think schools are going to want to revisit, I shouldn't say need, but are probably going to want to revisit their code of conduct policies and just see how long they really want their long arm to be, with the understanding that, there's now a flip side to exercising broad discretion. Let's see. Is there a good template in existence for written grievance procedures? Well, the good news is most of those grievance procedures have to be published in catalogs and made available on our website. So on the one hand, you could probably go online and there are hundreds, if not thousands, of examples available to you because most institutions, those annual security reports are going to contain them or they're going to have links to them. But there's lots and lots of stuff out there on the interweb that you could look to. The problem is how do you curate it and figure out what's worth replicating? You know, not to be self-serving here, but that's why you call your attorney. so you could have someone who's paying attention to this stuff who maybe says, well, we've got a template, or we did one for another school that we think is really solid, you know, and up to speed, and maybe you could look at that one, that kind of thing. But there are lots and lots of examples out there on the web. Let's see.
For the current rule, just to emphasize.
Yeah, for the current rule.
Don't be drafting any templates for this rule yet until we get a final one.
Yeah, good, great catch. Here's a very complicated question, Scott, that I'm going to pitch to you so you can handle it. This is a great question from one of our friends way out west. Okay, this is in quote, decision makers cannot rely on a statement that support that party's position if the party does not respond to questions related to their credibility, end quote, right? And that's something we read. As you noted, and I think actually, Scott, this was something you may have noted, similar language in the current regulations was vacated by Cardona. OCR also released updated Q&A guidance recently that's in line with Cardona and appears to be in contradiction with this provision. In light of both Cardona and the new Q&A revisions, any thoughts on why the NPRM includes this language? And Scott, it's fair to take a pass. This is a pretty complicated question, but I'm curious if you have thoughts off the top of your head.
No, I love this question because I had the exact same thoughts when I read this. So I actually went to the NPRM, the decisions, the language is around page 434 to 436. And basically the department's explanation is they're afraid of people gaming the system. They don't want a complainant to kind of write a self-serving email and then not answer questions, and then have the decision maker need to take that as true and accurate without having a chance to question it. So the exact same reasoning that the Trump administration put their rule into place, the department is convinced that they have solved the arbitrary and capricious problem that plagued the first iteration of the rule just because of the safeguards they've put into place, but yes, it's actually the very similar reasoning. They want to avoid a situation where one party can write something or say something and not be questioned about it.
Yep. All right, I think we have time for one more question. Our producer is giving me the electronic evil eye. So not really, Jacob, not really. So let's get to this last one. We'll take one more. And this, we'll skip towards the end here. So, and Stephanie, let me know if you want to sound off on this. Does the pregnancy modification requirement apply to employees in the same way that it applies to students?
Sure, Aaron. No, the very short answer is no. The modifications are only in the student subsection. There are certain things that need to be considered for employees, such as that lactation space, but they are looked at a little bit differently. Also, just note that other employment laws may apply to requiring accommodations for employees if they are disabled under the ADA, but the modifications that I spoke to earlier do apply just to students.
Very good. Hey, thanks everybody for hanging in with us. We really appreciate it. We know this is a lot to absorb. Again, hopefully this presentation, the slides, and some of the other materials we referenced will be helpful to you all as you wrap your brains around this and consider whether you want to make comments or not. And we do encourage you to make comments. You are the operators, the ones living with these rules and having to actually implement them and carry them out. And nobody has a better sense of what will work and what might not work than you all. So I encourage you, if you can, to participate in the process. And if you'd like to connect about the process, if you need help finding how to do comments or you just want to chat about them, we're always happy to chat. thanks to all, and have a great rest of your week and weekend. Bye, everybody.